Good afternoon, everyone. Welcome and thank you for joining us for SCOTUS, tariffs, and the Administrative State, a webinar co-hosted by the Journalist Resource and Econofact. I am Clark Merrifield, Senior Editor for Economics and Legal Systems at JR. I'm joined by Michael Klein, the William L. Clayton Professor of International Economic Affairs at Tufts University and founder of Econofact. Michael, I think this is our fourth webinar together, and
Yeah, that's right.
yep, and great to be with you as always. I want to introduce Oren Tamir, an associate professor of law at the University of Arizona, who teaches about administrative law, constitutional law, and comparative public law. Oren, thank you so much for being with us. And Naomi Lamoureux, the Stanley B. Resser Professor Emeritus of Economics and History at Yale University, also Senior Research Scholar at the University of Michigan Law School, and a Research Associate at the National Bureau of Economic Research. Naomi, thank you so much for being with us as well. We also do want to get to as many of your questions for those of you watching as we can. Please put those, if you can, in the Q&A box, not in the chat box. Please use the Q&A box. The Supreme Court on Wednesday will hear arguments in Learning Resources v. Trump. This case centers on the legality of the so-called Liberation Day tariffs that President Trump imposed on U.S. trading partners around the world on April 2nd. Specifically, whether the International Emergency Economic Powers Act gives the president the authority to impose those tariffs. If you hear any of us say the sort of comical shorthand IEPA, that is what we're talking about. And we will get to all the legal arguments about that case and the broader implications in just a little bit. First, I want to turn to you, Michael, and maybe you can give us an overview of these tariffs imposed since the start of the year, where we are at with this economically as the case gets underway in the High Court.
Thanks, Clark, and thanks to Oren and Naomi for joining us today. And thanks to all the people who are participating. So the background for this in terms of tariffs is that what the Trump administration has done is pretty much unprecedented. Tariffs have been used, since actually since the 19th century. In the 19th century, they're a major form of revenue creation for the government. But what the president has done to raise tariffs to the rates that we've seen, and also the volatility involved with tariffs, has been unprecedented. Economists tend to think that broad-based, large tariffs are not economically efficient and impose great costs on the economy. The title of the International Emergency Economic Power Act, it's not clear what the emergency is unless, the tariffs themselves are generating the emergency because of the uncertainty involved, the retaliation that's been taking place, and also the harm to the United States. So just as a background, a few things. Tariffs are like a sales tax, and like a sales tax, they're very regressive. Unlike a sales tax, the tariffs tend to raise prices of goods coming into the United States. Those prices are borne by American consumers. They also tend to raise the prices of domestically produced goods that compete with those. And unlike a sales tax, when domestically produced goods have higher prices, there's no tax revenue from that. Tariffs are supposed to protect industries. If they, in fact, are protecting industries by cutting off imports, then you're not getting revenue. Tariffs are very inefficient in that it's moving resources away from industries that are more world competitive towards ones that are not world competitive. And also, there's a great scope for corruption with tariffs, because if tariffs can be imposed and taken off very easily, you can imagine the kind of lobbying that would take place in order to put your own company or industry in a favorable position. So for these and other reasons, economists tend to, almost universally think that tariffs are a bad idea. What we've seen also is the uncertainty involved with tariffs being put on and taken off, raised to very high levels and then cut back. That leads to consumers and especially businesses being very reticent to undertake hiring or investment or make plans for the future because it's so hard to do in this kind of environment. And this uncertainty is weighing heavily on the economy. We don't really know if the economy is in a recession yet, but some indicators are pointing towards that. So with that as a background, I'm happy to turn it over to the next panelist.
Sure, great. Um, Thank you, Michael. And Oren, yeah, let's turn to you next. The This major questions doctrine is sort of at the center of the case that the court will hear on Wednesday. What exactly is the major questions doctrine? What does it mean? And also, how have the lower courts interpreted this doctrine in the context of this case?
Great. So thanks everyone for having me. And indeed, like, isn't it a cool name for a doctrine? The major questions doctrine. You want to write about it, you want to apply it, but what does it mean? And I think it is essential for the case. But let me just back up just a bit to say something about the kind of legal setup of the case. This case is not a constitutional case. It's not about, so far, the Trump administration doesn't claim that it does so just by the powers the president has through the Constitution. The Trump administration's claim is that the power to do the broad tariff regime is grounded in a statute, the IEEPA statute. Again, journalists are really great in finding acronyms. I don't think people said IEEPA beforehand. IEEPA essentially grants what sounds like a pretty broad authority for the president. It says that the president is authorized to regulate or prohibit importation of any property in which any foreign country or a national thereof has any interest by any person. But it says also under a condition that the purpose of that regulation or prohibition of the importation needs to be done in order to deal with any unusual and extraordinary threat to U.S. national security, foreign policy, or the U.S. economy. So that's the basis for the broad regime claim. And what had happened when the case came, when there was a first challenge and it came to the lower courts framed the question as an interpretive question and then invoked the major questions doctrine. So again, the interpretive question for the court was whether tariffs sound like are included within the terminology of the statute, regulation or prohibition. And the lower court said, no, tariffs are not part of regulation or prohibition. There's lacking an explicit wording about this. Where is tariff? Tariff is not like regulating or prohibiting. It's something more explicit. So the court wasn't willing to read, the lower courts weren't willing to read the regulation or prohibition expansively. But then, and here I sort of finally come to the major questions doctrine, the lower court also invoked that cool label sort of doctrine. And that doctrine, it's had a pretty interesting trajectory, but most clearly it was kind of announced in a Supreme Court decision called West Virginia against EPA that was decided in 2022. And the idea of this doctrine is essentially that when the administration or the president, the executive branch, is trying to do something that has major economic or political significance, it won't be usually the case that it would be allowed to do so under just vague or broad delegations or authorizations in statutes. What the major questions doctrine requires is a clear authorization, not something broad or vague, more explicit, that would signal to kind of outside observers that when Congress gave the power to the executive branch, it had more clearly in mind the kind of major policy that the executive is trying to do. And the argument here, the kind of rationale for the major questions doctrine, can be thought of as a kind of Congress is the most democratic branch that is supposed to do these major economic or political decisions, or as a kind of an idea that when Congress writes statutes, when it gives authority, it is not lightly giving a power that is major in terms of its significance. It needs to signal more clearly rather than just in a broad, vague language. So the court used that doctrine to say, well, because the term is so broad, regulate or prohibit in this IEEPA, it doesn't necessarily include the tariff. The tariff policy is a big, major policy and with a political and economic significance. We don't find it clearly authorized in IEEPA. So that was the kind of the argument that the court had made using the major questions doctrine to kind of limit a broadly worded statute in IEPA, in the authority in the context of the tariffs.
Great. Thanks, Warren. And so going back to West Virginia to that case, I guess, can you talk about how the court interpreted the doctrine in that case, and to what degree, can we provide some insight on how that might inform the court's thinking in this case?
Right. So here's a kind of an admission. The court was the idea of the major questions doctrine. It was announced in this case in a kind of a clear way, but the court was not entirely clear or kind of entirely authoritative and kind of guarding or kind of giving guidelines in terms of what would be considered a major political or economic decision in which the major questions doctrine applies. And so it gives kind of clues or kind of indications. So, for example, the majorness of the issue, how big it is, how consequential, is certainly something that is on the minds of the court, on the mind of the court. But the court had alluded to other sort of potential indicia for majorness that would trigger the major questions doctrine. So, for example, the court had said, well, we will look at how unprecedented, as Michael sort of used the term, how unprecedented the action claimed by the executive is. If there is some kind of a precedent, some kind of a past experience that suggests that what the executive is doing is not that novel, not that unheralded, then we can sort of say that this is not a major thing. Another thing that the court had said is that we might look at how the kind of past interactions between Congress and the president or the executive branch in this context might shed light or provide some kind of what sometimes lawyers say is a gloss on the willingness of Congress to recognize that. So, for example, if the authority in the statute was subject to frequent amendments that suggest that Congress was aware of what was going on in this area, that can provide indication or support, and that would kind of counterbalance the idea that this is a major issue. And I will say another thing that was not particularly mentioned in this West Virginia case, but another issue that plays a lot of that has a lot of significance in this particular case is that it is an issue about what is the kind of general domain of the policy. Is it a domestic policy concern or a foreign policy concern? And what the court had said, again, not in West Virginia, but in a line of cases that preceded the West Virginia case and somewhat after it, is that in matters of domestic policy, there is more force, or the court had suggested there is more force to this major questions doctrine, in part because Congress is indeed a kind of has a more institutional advantages, perhaps, compared to the executive branch in determining domestic policy. But in matters of foreign policy and foreign affairs, the suggestion was made that actually the force of the major questions doctrine is pretty weak and maybe even non-existent, in part because the president and the executive branch has an institutional advantage over Congress in leading on foreign policy and diplomacy and national security affairs, that would suggest a kind of a weakening, and if not a completely an exception to the major questions doctrine. So a big part of why the case is sort of unclear in terms of how it will eventually be decided by the Supreme Court, and we will see how the oral hearings go on Wednesday, is whether the court would buy in more seriously into this idea that this is a foreign affairs case. And in that particular context, the major questions doctrine that was so significant in supporting the lower court's decision that the tariff regime is illegal under IEPA would actually not apply.
So does that suggest perhaps the way this court might rule? I realize there's no way to predict these things, but is that sort of where you might be leaning in your thoughts on this?
So I think that the idea that this is a foreign relations case that provides an exception or a circumstance for the kind of weakened application of the major questions doctrine would be quite prominent with many of the justices on the court, and I would not be surprised if the court would land on that more authoritatively and reverse the lower court. But I also want to suggest that I'm really having difficulties, that more than the usual difficulties of predicting what the court would do, because I do think that there is another narrative that would have some significance in this case, and that would work against this idea that the major questions doctrine should not apply in the foreign relations context. And that narrative, just to put it very briefly, is a kind of an institutional one, or about the role of judging in a constitutional democracy. And it comes given the kind of when we look at the cases where the court had applied prior to this case, the major questions doctrine, it had applied it consistently to essentially block democratic administrations from pursuing ambitious regulatory policies. So the court, if it would be reluctant to apply the major questions doctrine here, even though it might have a kind of a powerful basis for application, might be perceived at the end of the day, as many had suggested when the court had birthed this major questions doctrine, as a partisan sort of doctrine that operates only in one direction, and that direction is a deregulatory one that essentially obstructs ambitious regulatory programs by democratic administration. So for a court that is worried about its institutional reputation and perception, that wants to be seen as a nonpartisan, as employing a doctrine in an impartial way, might be actually attracted to apply the major questions doctrine here, even though it has this escape hatch or complication or kind of a safety valve to rely on, which is this is a foreign relations case, so it's not a case appropriate for the application of the major questions doctrine. So again, Clark, I'm sort of like frustrating. It's like I always say that when I die on my tombstone, 2 words would be written, it's complicated. So it's complicated and it's hard to predict.
Yeah, yeah. Naomi, this case is part of what we might think of as a larger trend with the Trump administration, and it really gets at a lot of these powers of the executive branch versus the legislative branch. And one of the questions that we got from the audience is, how is this even, how are tariffs even a um, question here? It's clearly a legislative issue. How is this even allowed? But before we get to all that, we've all, I think, become very familiar with the term deep state and what it means to certain people. The administrative state is a legitimate thing that exists. Can you just sort of talk us through what the administrative state is so that we all have a baseline of understanding as to what that means?
Sure, and then I'll give you a sense of why people might call it the deep state.
Yeah, please.
So the administrative state is very simply the collection of agencies in the government that administer and enforce the law, and many of them are in the various cabinet departments, but there are also a number of other agencies that are primarily regulatory but exist independently of the cabinet departments. And collectively, they are the administrative state. And the administrative state it's as old as the nation. Goes back to the first Congress, which created what was then called the Department of Foreign Affairs, and the War Department set up the first cabinet departments. The administrative state grew pretty steadily over the course of the 19th century as Congress encountered problems that they needed specialists to deal with. But then the growth accelerates in the 20th century, and there's a particular flurry of administrative agencies created during the administration of Franklin Roosevelt, the period that we call the New Deal. And then there's another period where there's a lot of new agencies created in the 1960s and 70s, agencies like the Environmental Protection Agency. So the antipathy to the administrative state is really a reaction to that tremendous growth in administrative agencies in the New Deal and in the 1960s and 70s. And as you mentioned, critics call it the deep state. They call it that because the people who make up these administrative agencies are perceived to be independent from political authority to set their policies. So let's just take a moment there. The people at the top of these agencies are mainly presidential appointees, but the people who staff them, the bulk of the people who are employed by these agencies are civil servants. And they take examinations for their jobs, or either that or they often meet some kind of credential that's required for the job, like an MD for certain jobs or a PhD for other jobs. But what makes them civil servants is they are protected from political interference. They can only be fired for cause. And this too has a long history. So in the early to mid 19th century, most of the people who worked for the government were patronage appointments. They were hired because they supported the politicians that were in power. But over the course of the 19th century, it became clear that you needed people who had specific expertise to get the jobs that they were hired to do done. And so, for example, the Patent Office, as early as 1869, is able to get special dispensation to administer examinations for the people who are going to be the examiners of new technology. They needed to know things. And then in 1883, you get the Pendleton Act, which is the Civil Service Act. It initially applies to only 10% of government employees, but now it applies to almost all. And so it's these people that are often at stake in the complaints about the deep state, because they're hired for their expertise and they're protected from political tampering.
And I guess not to get into human psychology too much, but I think part of this fear, if people have a fear of the quote unquote deep state, is that it's people making decisions that were not elected, but as you say, are qualified for good reasons. I don't know. Are there historical examples of administrations taking things too far? Have we ever seen that before?
Taking it too far in what
In
sense?
in terms of perhaps um overstepping their bounds in some way, trying to expand their power.
Can I ask
Yeah,
a variant of that question?
yeah.
Does it become a convenient scapegoat to say, well, this administrative state is being very corrosive for the country by saying that these things are happening when, clearly it's within sort of their jurisdiction to do things. Is
And
there a historical precedent for that?
um, oh, certainly. So the controversies over the administrative state really come because the regulatory agencies that are staffed by them are doing things that some people like, some people want, and other people don't. So there's always effort to either rein it in some way, and also staff the agencies to the extent that they can be with people who are more conducive to your political position. So it's always, so in recent years, there's been, you always change the heads of the cabinet departments when you switch, when you change administrations. But there's been efforts to move further down into these agencies, into these cabinet departments, the number of positions that you can swap out when you come to power. And one of the questions that has stopped administrations is, what is their authority over the what is the president's authority over the people in the independent agencies, not in cabinet departments, who often have specific terms of office. I mean, we hear about this a lot with the Fed right now, but also other administration, other agencies, they have specific terms of office, and Congress has often tried to restrict the president's ability to remove those people before the terms of their office are completed. And those terms often do not coincide with presidential terms. So, for example, the case that is at the tip of everyone's tongue these days is Humphrey's Executor, which was a 1935 case in which the court said that basically that Roosevelt did not have the authority to fire a member of the Federal Trade Commission without going through a for cause demonstration of incompetence or conflict of interest or something like that.
Great, thank you. Question from the audience. Could this ruling in learning resources change the way federal agencies regulate? And Naomi or Oren, you can take this, but I guess the question is this solely going to affect these tariffs, or does it become a major precedent moving forward?
Doesn't it really depend on how the court rules, right?
Yeah.
So if the court applies the major questions doctrine to this, I think that will be a step toward curbing presidential powers, which they have otherwise been working hard to expand. We can talk about this later if you want, but there is the theory of the unitary executive. Warren, what do you?
So I totally agree. I mean, I think it would be it depends on how the court lands. So if there would be a robust application of the major questions doctrine, and the court would land in upholding the lower court's decision and saying that the tariff regime cannot survive under this IEPA, I think it would be a strong signal of limiting at least presidential power in the context of IEPA, which is, again, a kind of a broad emergency power regime that could, I mean, according again to, there's been an amicus curiae brief by professors who specialize in international trade. They are really worried about broad implications of a ruling that would not apply the major questions doctrine, that would allow the tariff regime. And they would say that this really is a broad loophole to use IEPA. And again, maybe a point that we should emphasize is that IEPA is a very broad authority for regulating importation. But part of the claim that was in the lower courts that justified a narrow reading of the statute and not allowing the broad tariff regime to exist under it, to be permissible under it, is that there are on the books other statutes that specifically are directed toward tariff decisions by the president. The reason that the Trump administration didn't use those other statutes is that those other statutes require some kind of process. They require finding by the president that there is indeed a case for the tariff. They require consultation, notice, so a kind of a more protracted process. The Trump administration did employ that process for some tariffs, but not for the broad regime. And a court that would land on limiting IEPA and saying that the broad tariff regime cannot be under it would safeguard these other statutes and the process safeguards that they entail. So that's one thing. I guess another thing is that if the court indeed upholds the major questions doctrine, it would cement that doctrine further. It would show that it's not a doctrine that is totally against democratic administration, that it does take potentially seriously, in some aspects at least, the kind of increased presidentialization or the increased dominance of the executive over policy. Of course, the reverse would be if the court lands on the other result, the signals would be kind of, the mirror image, that, IEPA could be used quite loosely, that the concern, again, from a broad use of presidential powers is not something that at least the court is going to enforce in this particular context. Maybe there are other battles to fight for the court might think other battles that are more important for the court to fight against the Trump administration. So really depends on where the court will go.
I just say that one of the really interesting things about this case and why it is so important for these other issues as well as for tariffs is that the court has been over the past couple decades been narrowing the authority of the administrative state in a variety of ways, using some doctrines like major questions doctrine, the non-delegation doctrine, also something called the unitary executive. And now it's in this bind where it's been using these doctrines to limit the administrative state, and now they're being turned back on it, especially the major questions doctrine, but also potentially the non-delegation doctrine is being turned back on the court to limit the executive, which is now it's in this bind. It's given the people seeking to clip the wings of the Trump administration the ammunition that they need to do it, and or if the court doesn't follow through, potentially embarrass the court.
Yeah,
so it's a really interesting bind that the court is in right now. I just want to say the suggestion that I was putting forward that I think would play with some of the justices on the court, and maybe the majority of them, is that they have a way to get away with it. And that way is that to kind of distinguish the story that you're telling, that the major questions doctrine is a story about the administrative state and clipping its wings. They would say, no, this is a case not about the administrative state. It's a case about presidential power. And in that realm, it doesn't raise all these difficulties and problems. And this is why we are okay not to apply the major questions doctrine and say this is a foreign relations case. This is a case about presidential power. The question is whether we should believe it, or whether the kind of the dilemma that Naomi is describing would be more meaningful, that no one would actually buy it, that the court can make those distinctions. And essentially, it's the MQD is a pro-Republican administration doctrine and anti-democratic administration doctrine.
I think, just on the plain reading of the title, the Emergency Economic Powers Act, it's very unclear to me what emergency this is addressing. You might not realize it, but the United States has had trade deficits, but for 1 or 2 years since 1975. And the United States is not in a situation like it was in 2020 or so, when we had unemployment reaching 12, 14%, inflation was spiking up. So it's really hard for me as an economist and not a lawyer to understand what's the emergency that this is trying to address. And furthermore, it's a little bit like you're not using a scalpel, you're using an axe. And, when you use an axe during surgery, you're not going to do a lot of good, you're going to do a lot of harm. And that's exactly what's going on here. So just on the plain reading of the doctrine, it's very hard for me to understand how a court could say, well, yes, this is a clear, case where there's an emergency going on. It's an economic emergency. This is the kind of thing that we should bring to bear on an economic emergency. And I know the court is not, very comfortable with economic arguments. And, in a lot of cases, I've sort of seen things that made me roll my eyes. But this seems so clearly not consistent with, the idea of an International Emergency Economic Powers Act. So I would urge people not to use the acronym anymore, so it becomes really clear, what they're arguing and how preposterous that seems to me and to lots of other economists. And the other thing is that with these tariffs, you can imagine a situation where there was like a national security interest, and so you're putting in place tariffs on a particularly narrow set of goods. These are just all over the place. They're varying so much. So that sort of is prima facie evidence that it's not making a lot of sense. If it really was a clear policy to try to do it, you wouldn't see this. You'd see more consistency and more targeting. So maybe Oren or Naomi, you could address, to a non-lawyer, how does this make any sense on just sort of this prima facie?
I'll just say, so there's one of the claims being put before the court, also by the parties and by a lot of the briefs, the amicus briefs filed for the court, is exactly what Michael sort of laid down about it's not an emergency. What are you talking about? Where the title says an economic emergency, the provision itself speaks about a credible concern for national security and on extraordinary circumstances, and this is not at all. And actually, Michael had a great way to put it. He said, what creates the potential emergency is the tariff regime itself, or the kind of unconventional circumstances. But I should stress that, again, the lower courts ran away from that claim, from policing the bounds of what would be extraordinary, what is an economic emergency. They ran away from it like fire. They said, this is not an issue that we have a capacity to determine, and we're willing to assume that even if it is an economic emergency, they move to the kind of major questions doctrine and the question of whether regulate includes tariffs. And I do want to say, just legally, it is there are good reasons to do so, or you can understand why the court did so, because conventionally the intervention of courts but in those questions about what constitutes an emergency, what are extraordinary circumstances, has been very thin and deeply deferential to the executive branch. That doesn't mean that this was a correct approach that we should live by today, or that the court would be correct to still hold. There is a good claim that, at least with this current administration that has a lot of indications of good faith and kind of being kind of easy with the truth, that a different approach is required. And in fact, there are scholars who argue that the court would have a capacity to make those determinations. I am somewhat skeptical that the court would go this way, in part because of its kind of conventional posture of just running away like fire from these kinds of questions. I'd be surprised to see something else, even though I think it is a plausible and attractive way for the court to think about it.
So can I pretend I'm a law school professor? And you always have these funny hypotheticals, right? So suppose that an administration said, well, we're going to invoke the International Emergency Economic Powers Act because balloons are floating over the United States from Canada, and they have little notes on them that say elbows up. And the administration says, well, that's an international economic emergency, and we are going to impose, completely prohibitive tariffs on Canada. If there's something that preposterous, would the court shy away from that? And is there any evidence that the court, so maybe we're in unprecedented waters where, most administrations would be ashamed to make, claims like this. So is it that we've never seen this before, of such a ridiculous claim? Or is it that no matter what, Oren, no matter what, how preposterous it'll be, they'll steer away from it?
No, so I don't think that no matter what, if it's facially preposterous, even this court might intervene. But this is really not entirely. I don't think that the court sees it entirely as something like that. I'll give you an analogy that is just, go back to the first Trump administration and think about something that was arguably also preposterous, or at least kind of seemed facially suspicious, claimed by the Trump administration. Again, the first iteration of the Trump administration. And I'm thinking about the travel ban case at the time. The travel ban case at the time, again, the concern was facially the Trump administration, the first Trump administration said it's national security concerns that underwritten the kind of policy at the time, but there was sufficiently credible evidence that this was not the motivating explanation, that it was animus and xenophobia toward Islamic nations. And to remind everyone, the Supreme Court stayed away from intervening. So I do think
But
so
in
long.
that case, didn't they pare back the sets of countries that they were going to not allow people to come from? I thought it started like really broadly, and then they sort of in
Throughout the
response they
litigation, but
pared
the
it back.
Supreme Court provided no remedy. If again, I need to maybe reread the case, and I don't want to mislead anybody. But in my recollection was that it was at the point where the policy reached the Supreme Court, it was upheld.
But I would
Well, but
just
at
remind,
that,
I would just
sorry.
remind everyone that the court is really behaving very politically in a lot of its recent decisions. And the only thing you can hope is that for a reasonable decision is that they're sufficiently concerned with the reputation of the court to try to make their decisions as consistent as possible. But it is a political entity, this court.
I mean, I have to say, Michael also suggests a kind of a clear, and I think many people sympathize with this view that there isn't a sensible economic explanation for the tariff regime. But
Right.
there are rifts within the conservative movement that, even though this is the conventional economic view, some believe that, there is, it's a kind of a, I can say it's a kind of a conventional Republican economics and a more Trumpian economics. And that sort of lens might be appealing to some, and it is appealing to some. And I don't think the court would see this clearly, as Michael suggests, as a kind of immediately preposterous. And at least where there is some kind of uncertainty on that, and given the kind of conventional approach of the court to stay away from these kinds of questions, my guess is that this is not where most of the action will be.
It's interesting that, as you're alluding to, Oren, the traditional Republican stance was for free trade.
Right.
And so, I was quoted by a journalist, although he didn't use this. I said, Trump is a rhino. He's Republican in name only,
Yeah.
because this is really moving very far away from what
Right.
the traditional Republican stance had been.
And you see
And
this
the
in the
Canadians advertised that fact, and then there was a retaliation against them.
Yeah.
And you can see this rift, by the way, from the amici briefs at the court. You see conventional, influential Republicans asking the court to intervene to say that this is an invalid tariff regime. So you see this rift.
I mean,
even
it's
in the
mainly
kind of-
business interests behind this case.
We have
But also,
go
just
on.
one other point.
Sure.
The business interests, it's unclear how they come down, right? Because we think about, oh, you're protecting steel or something. But, a lot of companies, very few companies or very few people are employed in making steel. Lots of people are employed in using steel in production. And we have an Econofact memo that's been very influential. The ratio of jobs that use steel to jobs that make steel is 80-1. And with international supply chains, it's really less and less clear that business is behind one side or another. It's really split according to if you're using imports, if you're competing with imported companies. And so it becomes, a very kind of muddied water situation in terms of who's benefiting. And I think, part of the rift is even within industry, you're going to see, differences across firms, depending upon whether they rely on imported intermediate goods or not.
We have a couple of questions along the lines of, stating that this court has shown a willingness, maybe even an eagerness to expand executive powers. So maybe this is, Naomi, a good chance to talk about the unitary executive theory, what that is and where that came from.
Okay, Well, the idea of the unitary executive is the idea that the president has absolute authority over the executive branch, and the focus has really been on the power to fire members of the executive branch at will. But where does it come from? Well, this is an originalist interpretation of the Constitution that emphasizes really one sentence in the Constitution, which is Article 2, Section 1, which starts by saying the executive power shall be vested in a president of the United States. And then also, it also relies on a phrase in Article 2, Section 3 of the Constitution, which gives the president the responsibility to take care that the laws be faithfully executed. And so the unitary executives say that the president has the executive power. That is what gives him this authority, and if there are any restrictions on his ability to dismiss members of the executive branch or people exercising executive authority, then he cannot take care that the laws are faithfully executed. So that's really the basis of it. And then the other side is the problem is it ignores other parts of the Constitution. The most important, there are several other parts of the Constitution that people criticize this view point to. But the most important is Article 1, Section 8, which refers to Congress and gives Congress the power, lots of different powers. But at the end of the long list of powers that the Constitution gives Congress, it says that Congress has the power to make all laws which shall be necessary and proper for carrying into execution the foregoing powers, and all other powers vested by this Constitution in the government of the United States or in any department or officer thereof. And so people who critique the unitary executive theory think that that necessary and proper clause gives Congress the authority to make the rules within which the presidential executive powers shall be executed.
And people are wondering what's going to happen in the future. You know, the court has been willing to extend executive power, and I think maybe you can talk about this more too. In recent years, accepting the unitary executive theory. Do you have a sense as to way the winds may be blowing in the future? Do you think the court may be willing to continue down this road?
Oh, absolutely. And in fact, colleagues of mine who are basically unitary executives find the trend worrisome because they're worried about the undermining of expertise in the government. But yeah, so the Supreme Court has already, in a recent case called Sealy Law versus the Consumer Financial Product Safety Commission, has really very much asserted this point of view. And in recent cases where the court has been asked to reinstate people who have been fired by the president in different administrative agencies, has indicated that it's likely to push that view further, and then oddly they have carved out in one of these shadow docket decisions, as they're called, a little carve out for the Fed. But whether even that will last, I don't know. I think Humphrey's executive, which is the decision which had limited the president's power to fire members of independent agencies is probably dead.
Can I just briefly say, totally agree with what Naomi said, but just 2 points on this, just to kind of mix it up a bit. To the extent that the next administration is going to be a Democratic administration, I just want to put it out there that to undo some of the things that the Trump administration, the second Trump administration has done, they would probably need to rely on the same very robust unitary executive theory. The question is whether they would be able to. I like this Michelle Obama sort of sentence of wherever they go, whenever they go low, we go high. So the question is whether the Democratic administration would, after utilizing this sort of tactic of unitary executive, would go high in the sense of would limit itself and reinstore a more kind of a checked, reserved image of a Democratic administration. And just one more point, and it also goes back to a theme that Naomi raised prior, which is about this dilemma. I mean, the introduction of the major questions doctrine seemed to have at least counteracted some of the trends of the unitary executive or a robust executive power. There's another decision that is important to throw out there. The overruling of Chevron deference that this court was really enthusiastic about is also a weapon waiting out there for smart litigants who are already kind of using it to potentially use and kind of confront at least the lower courts and this Supreme Court with the kind of conflicting impulses that it has, on the one hand of empowering the executive under a unitary executive story, and on the other by taking back delegations and authority and deference on questions of law. Again, it's a complicated theory, but it just complicated this.
And it's so the other thing I would just second of Oren's point is that this cuts both ways politically, and the Humphreys executive decision was written by by one of the most conservative justices ever to serve on the U.S. Supreme Court, and was written as an attack on the Roosevelt administration, was handed down on the same day as other famous decisions that curbed the power of the Roosevelt administration, including the one striking down the National Industrial Recovery Act. So this is all politics, all the way down.
On that point, I mean, so you're saying that there's precedent, but this Supreme Court seems to care little in some cases for precedent. So if the Supreme Court has really become a political arm, and they say, well, it applied there, but it doesn't apply here because they don't like the administration, they're not enthralled to the administration. I mean, as an outside observer, I have deep cynicism about the Supreme Court's, sort of honoring precedent or doing, sort of legally the right thing. And so has it just become, so my more conspiratorial moments, is this just a Supreme Court that's, completely politicized?
Well, it may be, but in Selah law, which is the one that treats Humphreys executive as an exception. That's kind of right, because when Humphreys executive was handed down, it was trying to position itself relative to a decision by the Taft Court in the 1920s called Myers versus the United States, which involved an effort to dismiss a postmaster. And Taft, who wrote the decision and had been president of the United States, upholds the president's power to fire postmasters and against a law which had been enacted in 1876 that said that the president needed the advice and consent of the Senate to do that. And so Humphreys executive comes a decade after that decision, and they carve out an exception from that and saying, well, yeah, so we have Myers, but in this case, this is an independent agency which was set up by Congress in a different way. So we need to make an exception for that kind of independent agency, which is really not not doing executive work. And so Roberts Court is following that decision, saying, yeah, that's right, that was just an exception. And we're going to make sure that that exception is applied very stringently. And so the president does get to fire people who are who are exercising what is essentially executive authority.
So, there's an old saying that some people use economics like a lamppost, not for illumination, but for support. So it seems that you can kind of, given the long history of the court, you can kind of pick and choose what you want.
Exactly.
And
Yeah.
it becomes very political. So it's not calling balls and strikes,
Right.
as Chief Justice Roberts says. It's much more politicized than that. Again, as an outside observer and not an expert in this, but has it just become incredibly politicized?
Well, it has, and the court always finds ways to get to the outcome that it wants to, right? Taft, in his Myers decision, really cheats, I think, in his analysis of the first Congress. He says, well, the first Congress supported the idea of what we would now call the unitary executive. And but that's really a misreading of what happened in that first Congress. And very recently, one of the architects of originalism, a guy named Caleb Nelson, has said no. In fact, the unitary executive is not supported by an analysis of what went on at the time of the framing. It is not a true originalist position. So some people are really trying to figure out what the Constitution says and what was meant, and other people are using it politically, and they can't all be tarred with the same brush.
I just want to say very briefly, I mean, my views are complicated about how to frame this court. It's clearly not a court that calls bulls and strikes. I think that was a really bad metaphor to understand the law. But I think the way to actually the tariff case, when I think about it, it's actually a really good way to understand how law works, because it's a high stakes issue. The legal materials are indeterminate, ambiguous. They can lead to different kind of results, and to understand how a court or a particular justice will decide will really require, it's a complex sort of judgment that involves on issues about how to navigate the kind of legal rules that exist in place, but also the kind of what is the narrative, the larger high politics narrative about the court, its institutional place in a constitutional democracy, and in kind of overall regime politics of conservative movement and the democratic sort of resistance to that. So a complicated answer. I can't just say it's a political court. The law itself has a lot of political origins.
And speaking of complexity and narratives, just to sort of bring things back for the journalists in the crowd, the poor journalists who have to write in plain language or speak in plain language on video, trying to explain all this, as you said, Oren. Pretty complex case, not entirely clear. We'll get more clarity on Wednesday as to where the judges are, I think. But any advice, any thoughts, Oren, on the coverage that you've seen so far, and any ways to boil the complexity down, I guess, in a way that a broader public could understand?
So I do think, of course, that effective reporting can boil down. I mean, it won't boil down to a simplistic answer, yes or no. Complexity can be conveyed in a way that I think the general audience will be able to understand. I think the key here is to kind of follow the way that how first the lower court thought about this case, focus on the kind of the language of the IEPA statute, the way that the lower court thought that the regulate or prohibit language in IEPA is not enough to include a tariff policy, that the major questions doctrine also played a role in kind of its thinking, and then suggesting how the way that the lower court sort of thought about it is actually could be complicated, especially given that regulate and prohibit seem to be a more a more broad, allow even like the lesser is included in the kind of the more, and the major questions doctrine is kind of potentially more complicated with the foreign relations context. And then to abstract away from that particular story and introduce the institutional pressures that the court is feeling, given that it applied the major questions doctrine only against democratic administrations, but also the larger context that Naomi and Michael introduced about how the court is going to perhaps reserve its resources to deal with the Trump administration in other junctions. How many wins, how many losses the court is going to give that administration. I think it's also a thing that will play in the minds of the justices.
We have one more question I want to get to. I know we're at time, but this should only take a minute. It's interesting. Just a couple questions from the audience along the lines of what happens to the tariffs already collected if this is overturned. I realize that's sort of a specific question, but I wonder if anyone is able to shed some light on could the court order that businesses who have paid tariffs, be paid back? We're talking about, I don't know what the total is right now, but it's billions and billions of dollars in tariffs that have come in.
I suppose that the Trump administration is going to rely, if the court prevents the Trump administration to rely on IEPA, I assume that the Trump administration will revert to the other statutes that envision a more protracted process and will probably ask courts, to the extent that there would be challenges, to ask for a reimbursement or a repay of the illegal tariffs already levied, that there will be they will ask for stays until that would kind of play out. I think that's probably what's going to happen. But it's, of course, it's going to be tricky now, and lower courts will carry the burden to figure out what to do with those issues.
I would also mention that the administration has touted the amount of money raised from tariffs, but the money is mostly being raised from American companies and American consumers, not from foreigners. We have Econofact pieces on that. One of our pieces is by Alberto Cavallo, who's at Harvard Business School and has data, like literally daily data on thousands and thousands of products. And we have a memo by him. And this was from early September. Recently, his work has been cited as estimating that 0.7 percentage points of the 3% inflation rate is due to tariffs. So also just, sort of, if people are interested in tariffs and the consequences of tariffs, econofact.org is a good site for you to find out a lot about it. And, as Clark was saying, in plain language, it's very accessible to help inform your reporting.
And Michael, we did a webinar in January about the tariffs. It was a week, I think, before Trump took office, talking with experts about how they work, how they trickle down, so to speak. So if you go to journalistresource.org and type in tariffs, you can find that. We're over time, but Oren and Naomi, it's been really helpful, really great to have you both here, and thank you so much for spending time with us today.
Yeah, thanks a lot.
Yeah, and we will get the video posted as soon as we can, and I'll be doing a write-up of what we talked about here. If you don't have time to watch the full video, that again will be on journalistresource.org. And Michael, any other plugs or thoughts or anything you want to add before we sign off?
Just, this is something that's going to affect people more and more. The evidence is that tariffs are feeding through more and more into consumers' prices. And of course, we're seeing, retaliation, like the soybeans from North Dakota, where I was a few weeks ago. People were complaining that China has bought 0 soybeans from America as opposed to huge amounts a year ago. And that's really hurting people. So your local stories too could reflect the consequences of these trade policies by the administration.
And that's great. I'm glad to end on that because someone had asked about the effects of the tariffs on soybeans. So yeah, we will leave it at that. And thank you all again. Thank you all for being here and listening and being with us. And we'll get all the follow-up stuff up on our websites shortly. And we will see you next time. Thanks, everybody.